Hello, welcome back to the series on jurisprudence. This is a new video which talks about the relationship between law and morality. Law and morality has been a central topic in legal philosophy. While law and morality are distinct concepts, they often intersect and influence each other. Law refers to the rules and regulations enforced by the state, whereas morality pertains to the principles of right and wrong that guide individual behavior. So, the key question in this discourse is to what extent, if at all, law should reflect moral principles. Natural law theory suggests that law and morality are inherently connected. According to this view, valid laws are those that align with moral principles derived from human nature or divine sources. Thomas Aquinas has argued that human laws are just when they are derived from natural law, which is based on moral principles inherent in human nature. Aquinas believed that an unjust law is the one that contradicts natural law, and it is not truly law, but rather a perversion of law. Example like laws that protect life, such as those prohibiting murder, are valid because they are aligned with the moral principle that life is inherently valuable. Cicero, an ancient Roman philosopher, stated that true law is right reason in agreement in nature. It is of universal application, unchanging and everlasting. He believed that law should be based on universal moral principles that are consistent with human nature. So, the moral principle that theft is wrong should be reflected in laws against theft. So now legal positivists maintain that law and morality are separate entities. According to this view, the validity of law is determined by its source, example a legitimate authority, rather than its moral content. So, Austin, a leading positivist, argued that law is a command issued by the sovereign and backed by the sanctions, regardless of whether it is moral or not. For Austin, the law is what is laid down by an recognized authority, and its legitimacy does not depend on its moral content. A law, for example, a law that imposes taxes, even if some might view that it is unjust, is still valid because it is enacted by the proper authority. Now, another thinker in legal positivism, H.L.A. Hart, differentiated between law as it is, that is descriptive, and law as it ought to be, that is normative. He argued that while law can and often does reflect moral values, it is not necessary for a law to be moral to be valid. So, law is a system of rules and its validity depends on social practices, not morality. So, for example, a law allowing capital punishment might be valid in legal system, even if some other consider it morally wrong. Now, legal realists focus on how laws are applied in practice and argue that law is influenced by social, economical, and psychological factors rather than abstract moral principles. Oliver Holmes Jr. argued that law is what courts do in practice and that judges often make decisions based on their own experiences, biases, perceptions of social needs rather than purely moral or legal principles. He famously stated, the life of the law has not been logic, it's experience. For example, a judge might rule differently on a case of theft depending on the circumstances of the thief, such as stealing out of necessity versus stealing out of greed. Jerome Frank, another realist, emphasized the unpredictability of law due to the subjective nature of judicial decision making. He believed that personal biases and social influences often guide judges rather than an objective application of moral or legal rules. For example, two judges may interpret the same law differently based on their personal views on morality or justice. Now, critical legal studies scholars argue that law is a tool to use to perpetuate social injustices, and that it is of and it often marks the true relationship between law and morality by presenting itself as neutral or objective. Duncan Kennedy, a leading figure in critical law studies, argued that legal reasoning often serves to justify existing power structures and the apparent neutrality of law is a myth. He believed that law is infused with moral and political choices that reflect the interest of the powerful. For example, laws that regulate property rights may appear neutral but can perpetuate inequalities by favoring wealthy property owners over poor individuals. Roberto suggested that law should be seen as a tool for social transformation rather than merely a set of rules to be followed. He advocated for a more fluid understanding of law where moral and social considerations play a significant role in legal decision making. For example, in areas of civil rights, the law should actively promote social change rather than just maintain the status quo. So, intersections and conflicts between law and morality. So, when does law reflects morality? So, in case of human rights law, many human rights laws are based on moral principles such as the inherent dignity of the individuals. For example, laws prohibiting torture reflect the moral consensus that such acts are inhuman and unacceptable. Environmental laws aimed at protecting environment often reflect moral concerns about the responsibility to preserve the planet for future generations. So when law and morality diverge, in case of immoral laws that are morally contentious or widely regarded as unjust, create a conflict between law and morality. For example, apartheid laws in South Africa were legal but widely condemned as immoral. Legal but immoral actions. Some actions may be legal but considered immoral by certain groups. For example, laws that allow for capital punishment are seen by some as legal but immoral. So, what are the practical implications of this? When law and morality conflict, individuals may engage in civil disobedience, the act of breaking the law on moral grounds. This is often justified by the belief that moral obligations outweigh legal duties. For example, the civil rights movement in the United States saw widespread acts of civil disobedience against segregation laws, which were legal but considered morally wrong by many. Judicial interpretation. Judges sometimes rely on moral reasoning when interpreting laws, particularly in cases where the law is vague or open to interpretation. In cases involving the right to privacy, judges often invoke moral consideration to extend protections not explicitly outlined in the law. So, in conclusion, we can say the relationship between law and morality is complex, multifaceted, with various theories offering different perspectives on how these two domains interact. While natural law theorists argue for a closer connection between law and morality, legal positivists maintain that they are distinct. Legal realists and critical legal scholars further complicate their relationship by highlighting the influence of social, economic, and political factors on the law. Understanding these different viewpoints is crucial for grasping the role of law in society and its potential to both reflect and shape moral values. In the next lecture, we'll look into the meaning of law, sources of law, and other aspects of law. And then we'll move into the various schools of jurisprudence. Thank you for watching this video.